Wetlands are an important feature of our landscape, but a recent Supreme Court decision has removed federal Clean Water Act protections from many of them, and that has a lot of people concerned.
For over 50 years, we've counted on the federal Clean Water Act to protect these places for our communities, and now all of a sudden, the Supreme Court has blown a hole in those protections.
In May of 2023, the U.S. Supreme Court ruled on a case about wetlands. Officially, it's called Sackett versus the Environmental Protection Agency.
If they get this fine, they're done.
In 2007, Michael and Chantel Sackett began developing a parcel of land to build a house near Priest Lake in Idaho. But the EPA halted the project, alleging the property was a protected wetland under the Clean Water Act. The Sacketts sued. The Clean Water Act only protects waters of the United States, and the Sacketts said their land wasn't one because there was dry land between it and Priest Lake. Howard Lerner is executive director of the Environmental Law and Policy Center.
So the Mississippi River is a water of the U.S., no question. A tributary that connects directly to the Mississippi River is a water of the U.S. The question is, if you have a wetland that on an intermittent basis connects to a tributary of another tributary that goes into the Mississippi River, is that a waters of the U.S.?
In the Sackett ruling, the court's conservative majority, minus Justice Kavanaugh, voted in favor of a new standard. According to the majority opinion, to count as a water of the United States, a wetland must have a continuous surface connection to a navigable body of water. If it doesn't, then federal Clean Water Act protections do not apply. Environmentalists like Lerner strongly disagree.
The Supreme Court's misguided decision in the Sackett case essentially hamstrings the federal government's ability to regulate and protect wetlands.
Builders and farmers, on the other hand, generally support the ruling, saying it will prevent the EPA from encroaching on property rights.
All this sort of confusion of what is and isn't a federal water of the U.S. has led to a lot of uncertainty, particularly among public owners, school developers, state departments of transportation, about whether to proceed with a project. So it's led to a lot of delays and a lot of increased construction costs.
Brian Termale of the Associated General Contractors of America says his organization welcomes the ruling because it provides clarity.
And what the Supreme Court did was they were very clear in identifying what is and what is not a water of the U.S.
But while the new definition may be clear, environmentalists say it isn't logical. Paul Botts, executive director of the Wetlands Initiative, points to a wetland in Indiana Dunes National Park on the southern shore of Lake Michigan to explain why.
This wetland over my shoulder, which is separated from Lake Michigan by this dune we're standing on, is in fact hydrologically part of Lake Michigan. It goes up and down with the lake levels. But according to 5 justices of the Supreme Court, that is no longer a federally justifiable or regulatable wetland.
This wetland will be protected even without the Clean Water Act, since it's part of a national park. The Sackett ruling doesn't impact wetlands on public property, but the vast majority of wetlands are on private property. And environmentalists argue that whether directly connected to another body of water or not, those wetlands provide wildlife habitat, filter water, and more.
Isolated wetlands, as they've been called, are every bit wetlands, just like any other wetlands. They provide all the values and services that wetlands provide, and in fact, they provide flood control. They are great natural sponges. That's actually, in some ways, the most top-of-mind value, particularly in the context of our climate that is changing around us. And having lots of wetlands scattered across the landscape, which is what nature bequeathed to us in the first place, is a great thing for that.
Today, there are far fewer wetland areas in this region than there were a little over 100 years ago.
In a blink of an eye, we got to remember that the American Midwest went from indigenous peoples living in a wild landscape to more or less modern, developed, human-built landscape in just a few human generations. So it's an enormous loss in, really, in the big picture, a remarkably short period of time.
A perfect illustration of what we've lost is the Grand Kankakee Marsh in northern Indiana. At one time, it covered nearly 1 million acres, stretching from what is modern-day South Bend to the Illinois border. But it was drained for farmland in the 1800s, and today it's just 5% of its original size. It's estimated that the 8 states in the Great Lakes region have lost anywhere from 60 to 90% of their original wetlands. They've been drained to create farmland or filled in for roads. Jack Darren is Illinois director for the Sierra Club.
Most states in the country have lost well over half their wetlands, and so this incredibly high-functioning ecosystem that protects us all is mostly gone. And the ones that remain, these wetlands are working at least twice as hard to provide those flood protection, wildlife habitat, and drinking water services for us.
Certainly in the century since the Grand Kankakee Marsh was pretty thoroughly destroyed, we have gradually gained, and in recent decades more rapidly gained, much more knowledge both about the value of wetlands and about how to restore them. And they can be restored. They can be restored even when they've been drained, ditched, flattened, etc. for, generations.
In fact, part of the mission of the Wetlands Initiative is to design, restore, and create new wetlands. Since 1995, the group has restored about 8,000 acres of wetlands and tall grass prairie in Illinois and Indiana, but there are limits to what can be done.
We're not going to move the interstates or the railroad lines or the city of Chicago or many other things that were built on or on top of or next to wetlands. So we can restore to really remarkable high quality now if we have the will and the means, but it's not cheap and it's not easy.
While the Sackett ruling removes federal protection from some wetlands, state regulations remain unchanged, but some states have weak regulations. Illinois has some of the weakest in the Great Lakes region, which has activists and legislators there racing to adapt.
I think the most important thing now is for our local governments, our states that have for decades counted on the federal government to protect these crucial areas, to step up and put their own protections into place.
And we're working with a number of our colleagues at the Wetlands Initiative, a number of the conservation groups in Illinois, to say, how best can the state of Illinois step up to protect wetlands?
It is a remarkable engine of value. It reduces our flooding. It cleans our water. It both harbors and nurtures a lot of really beautiful wildlife. View a wetland as one of nature's gifts to us.